And I will share my stuff here, sound, screen, share, and we're rolling. So today, case law and case laws, well, case law opinions. And then most importantly, we're going to go over how to update your research, double check that what you found statutory and case-wise is still good law, because that's the most important thing that you can do for yourself when you're doing legal research. So for today, in the usual format, cases and updating in a quiz type format. I'll throw out a couple of my research tips. If nothing else, you should take away from this session. And then I've got one Lexis and one Westlaw research fact pattern exercise for you guys to go log into the platforms and see if you can, find the answer. And then before I sign off, I'll go over the legal research project. All right, so I'm sorry, my stupid quiz. What is meant by stare decisis? This is important. This is like the foundation of American law. So when you hear stare decisis, what does that fancy Latin word mean? Dominic.
The decision stands.
Decision stands, okay. Tom, do you have something different?
Yeah, it's that it's the precedent that you have to adhere to of cases. So if the decided case is whatever the decided case is a seminal case, you have to adhere to the ones that follow that thinking.
Right. You're both correct. So stare decisis, Latin for the things to stand by things decided. So like Tom says, the doctrine of precedent. So if a court in your jurisdiction has ruled on a situation, you as a lawyer, you in your case are going to have, your court is going to have to follow that decision within their jurisdiction up until the time that a higher court has overruled it somehow, either the state Supreme Court, or if it's a constitutional issue, if the United States Supreme Court has overruled a decision, then you wouldn't necessarily rely upon that opinion anymore. But up until the point an appellate court decisions is overruled by an upper level court, the lower courts in your jurisdiction have to follow it. So Pennsylvania appellate court decisions, they stand and must be followed until the Pennsylvania Supreme Court overrules that decision. So back to weight. How much weight would a New York trial court have to give to a Pennsylvania Supreme Court decision, if any? Carrie.
It wouldn't have to give any, it would just be persuasive.
Exactly, it would only be persuasive. Now, novel issue of law, I mean, in law school fact patterns, you're probably not going to be dealing with these nuances, but in the real world, there are plenty of times that a court hasn't addressed a novel concept of law and a neighboring jurisdiction like New York or Maryland may have. So you would throw that in as persuasive authority, but you would never expect your Pennsylvania court to follow it out of necessity. All right, on to cases and opinions. When we say a reporter, what is meant by what am I talking about when I say a case is found in a reporter? Did anybody glean that? Yes, go.
That's where they publish all the cases for that specific jurisdiction or
So Pennsylvania Reporter has Pennsylvania opinions, etc. The U.S. Report says the United States Supreme Court opinions. Correct. Back in the days where the law library ruled, we would have stacks and stacks of all of the print reporters, the Pennsylvania reports, the US reports, even the New York reports. I mean, my entire library was filled with reporters, mainly because the American Bar Association required it, and B, because Westlaw and Lexis weren't up and running and didn't have everything online like they do now. But as you said, it's mainly now for citation only. So that when you cite a case in your brief or your legal memorandum, there has to be a systematic way of referring to that case so that the person that's reading your brief can find it either on a legal platform form of some sort, or if they're still old school, they can go to a law library and pull the print volume down off the stacks and read it that way. So back in the day, there were two related entities, publishing entities. There was the official reporter, so screenshot of the Pennsylvania state reports. That's your Pennsylvania Supreme Court opinions there. And it would just be the opinions in the order that they were handed down and then run to the publisher and given to the library. And then a little later, the Westlaw people came along and they created these regional reporters like the Atlantic Reporter, where opinions in a region would be pulled together. And then in addition to the opinions, they would add head notes, which would summarize the opinion. And then they would also include topic and key numbers, which was also another tool for researching opinions and finding other types of opinions that are similarly situated. So the official version would be none of these enhancements. And then the regional reporter, the Atlantic Reporter, the Pacific Reporter would have the editorial enhancements. Yes, Carrie?
I just wonder, if I'm reading Blue Book correct, it makes it look like the Atlantic Reporter is preferred over the Pennsylvania State Reporter for Pennsylvania. Is that accurate?
That's right. You've jumped my next question. Why does the official reporter matter? And you've answered that because that's what you would cite to. You usually cite to the official reporter, usually, which is where your rules of court come in as well. Out in the real world, you're not going to rely on the Blue Book. You're going to rely on the rules of court for them to tell you what publication format, how to cite to a case. In your law school world, you're going to be in the Blue Book. So here's a screenshot, like Carrie says, Pennsylvania, the Pennsylvania reports, the Pennsylvania opinions in the Blue Book. So Supreme Court, Pennsylvania, if you're citing to them, you cite to the Atlantic 2nd Series or Atlantic 3rd Series, if that case appears in there. And then if it doesn't, then they give you a laundry list of other options that you can cite an opinion to. All right. And similarly, Supreme Court, Superior Court, and it would go on down, trial courts, etc. Here's your parallel citation, Carrie. A screenshot of an opinion on Westlaw. Up at the top of the screen, they have two citations. One to the Pennsylvania reports. So volume 592, page 581 of the Pennsylvania report. And the Schmel case is also found in the Atlantic 2nd, 927, page 183. So yes, Jenna.
I have a question on this. Even after the reading in the Blue Book, I'm still not 100% sure. It's not sinking in. Why do I have to parallel cite and when?
You don't necessarily have to parallel cite. it would, yeah, again, that would depend on the court rules. Chances are you don't have to. I'm not sure how specific your methods faculty are. Because there's really no reason, because bottom line, the primary reason for citation is so that somebody can go out and find it, right? So if you've got, like the Blue Book says, the case name, the citation, the reporter, and the year, anybody can go out and find it on Google, on Westlaw, Lexis. Parallel citation comes in maybe if, I don't know. Actually, I don't know why.
Okay, that makes me feel better.
don't know why
It feels, I mean, I sat and stared at the wall over. I'm like, why would I ever do this?
I mean, sometimes to double down, they might throw in a parallel site. So if somebody doesn't have access to the Atlantic, they can find it on the PA reports at their local library or something like that. That's what I can come up with.
Okay, I'll take it. Thank you.
All right. Did somebody else have their hand raised?
Yeah, that's me again with this parallel site. They talk about public domain citations with
Uh-huh.
regards to parallel site. Can you go into that a little bit? Because we haven't really talked about that at all.
Okay, this is way in the weeds now. And you won't need that for any of your legal research assignments or methods assignment. The electronic format citation, domain citation. There was this effort, I'd say 8 or 10 years ago, that they're trying to get away from the reporters and having people to pay for subscription databases. So all of the courts were uploading opinions onto their own servers. So that's what that was talking about. So you could go to the AOPC website, Administrative Office of Pennsylvania Courts. So their public citation system. So that would be a way of identifying it that, hey, I got the Schmel case on the AOPC server. But I don't think it ever really took off. I mean, that's probably raises more questions than it answered, but that's the premise and concept behind that. So in your research on Lexis or Westlaw, you may run across an opinion that has unreported or unprecedential tacked to the page. Can you cite to that? What do we think? Let's go with the chat bomb. 1 for yes, 2 for no, and 1, 2, 3, hit a number. Let's see, why can't I pull up? It seems like we're 50-50 split here. My answer is maybe. Like everything else, I hedge, maybe, because it depends on your court rules. Or in this case, not your court rules, but your professor's, the parameter of your professor's assignment. What range or what range of opinions they want you to rely on. So you check your court rules out in practice. An example is Pennsylvania Rule of Appellate Procedure 126 that says, yes, you can cite to an unreported or unprecedential opinion for its authority if it suits your needs, basically. And then if you go down the requirements of Rule 126, I think there's some references to if it was handed down after a certain date or something. But yeah, in Pennsylvania, you could cite to an unreported opinion. So if we're needing to find court rules, where do we find them? And what are you showing me there, Carrie? The rules of court?
The Federal Rules of Civil Procedure.
Rules of Civil Procedure, right? So Federal Rules of Civil Procedure are all over the internet. The local court rules are going to be all over the court websites. The law firm that you clerk for, they may have, I guess I don't have a screenshot. They may have the print volume of the Pennsylvania Rules of Court. Those are really handy because they're all in one set. You'll get the civil procedure rules, you'll get the evidence rules, you'll get the child custody rules, you'll get the local rules all in one little neat thing. So the firm libraries are good with that. Next question. Here's a screenshot of an opinion on Westlaw. And at the top of the opinion are these head notes, summaries of the case. Would you cite to the language in the footnote? 1 for yes, 2 for no, and 1, 2, 3. All right. Good job. Everybody's given me a no, and that is correct. 2 guesses, and you don't need 2 guesses because the head notes are just editorial enhancements, editorial summaries written by a lawyer that was hired by Westlaw or Lexis to massage their product better. So it's not the official opinion. You need to scroll down to where the actual opinion is, and that's what you would cite in your brief or your memorandum. Yes, Gull.
So I was looking at the, you can hit the head note and then it'll take you to where in the opinion they basically got that information from, and then it's appropriate to then cite that information,
It
correct?
would be appropriate to cite that where it was in the opinion, and then you look on the screen, there's a little asterisk with a number, and that's the page number in the reporter. I'll show you guys that when I go online. So where are judicial opinions found? Back in the day, it was all in print. You'd have the official reporters, and then you'd have the regional reporters that would have a region of the country all together with the editorial enhancements. And then there was also reporters that divided things by subject. So you'd have the West Education reporter. There's a Pennsylvania tax reporter, I think. So there's a variety of reporter sets. Now that everything's online, it's not really that critical of an issue, but there are some things that we still pull from the reporters, the topic and key numbers, so that you can do subject matter searching. So if your terms and connectors search don't find what you think you need to be finding, you can run your search using a terms and connectors or a subject search electronically. So your Lexis, your Westlaw, and then I've also made references to the court websites as well. Last ditch effort, you need to find a case, you can go to probably your court websites for the variety of states and find a limited number of opinions uploaded to their server as well. So here's my nice little scenario for some of the rest of our talk here. Our buddy, the Widener quarterback, having a great season, so he's been interviewed by the local press quite a bit. And without his permission, a local cheesesteak joint took a clipping of his interview and used it in one of their commercials that claims him to be promoting them as having the greatest cheesesteak in the Chester metro area. And he didn't give permission for this. Does he have a cause of action? Of course, I've never handled this right, so I do one of these. Don't know. So, little history here. Back in the day, when print ruled the world, And Westlaw and Lexus were on these dedicated terminals that were hardwired into a phone line. So this is about mid-1980s. They still had these when I was in law school. The problem with Lexus and Westlaw at the time is not everything was uploaded, right? It was expensive to purchase the product, and then not everything was uploaded because not every court had things digitized to be uploaded. So you still needed to rely on the print reporters because the print reporters had everything. So to be able to access print reporters, the West folks had to create the digest system so you could actually research in print. So the West Pennsylvania Digest, you're looking for a topic and a key number. They break the entire body of American law down into roughly 400 broad topics: torts, infants, insurance, zookeepers, whatever, alphabetically. And then each broad topic was broken down into narrow key numbers. So you would use a descriptive word index to hopefully find yourself a topic, torts, and a key number, 389. So torts, right to publicity, 389 is use of somebody's voice. This is in the library using volumes and volumes of reporters. So you'd go to the volume of the reporter that had torts 389, and you can see here, it'll give you a little paragraph summary. This is similar to the notes of decision at the end of the annotated statutes, right? So a paragraph summary of the opinion, and then the citation to the reporter that was in. So I could go to the library, find 488, FedSup, turn to page 491 and read this Fonseca case, which says, no, you can't steal an NFL player's voice for a radio commercial. But we're not going to do all of that because we've got this thing called the internet, right? So how do we search? By citation. If you've already got a case on point, you pull it up by cite. You're going to look for a secondary source that's going to point you to a statute and a couple of cases on point. You're going to use an annotated statute. So if you find your statute in the secondary source, you're going to pull up the statute online and you're going to read the notes of decision that are connected with your, with your statute. And then you might also use subject matter searching, sort of like the topic and key number system, but it's been translated to the online environment. So obviously citation. So here's my Facenda. I wrote down my 488 federal sup second 491 and it pulls up. But I got a nice big fat red stop sign there. So from the time that the digest was printed to when I went online, it's been probably overruled, it looks like. Secondary source. I go on Westlaw. I searched all content. Right to publicity and voice. Now I've done this fact pattern many times, so I knew it was right to publicity, right? So it might take you a few cracks at it. You wouldn't know it. You wouldn't know it's necessarily a tort. So you'd be throwing out keywords like use of voice, unauthorized, advertisement, something like that. So by the by, you'd finally wind your way down to it's a right to publicity, it's a tort and a voice. And in the secondary sources, you would see cause of action for infringement of right to publicity as one potential article. You'd click on that. I do a control find for Pennsylvania here, and it gives me a couple of cases right in the secondary source. So chances are, if I click on these two opinions, I will see if there's a statute involved, and I'll see some of the general principles in this sort of cause of action. I might search for the statute. In this secondary source, Apple Core Case or Fennell, they're going to give me this Pennsylvania statute 42 PACS 8316. So I would take that online, Lexis and Westlaw, pull it up, and I see that Pennsylvania legislature has spoken to the unauthorized use of name or likeness. When a cause of action is established, who can bring action, et cetera. So it's kind of all laid out there for me. So I went from doing one of these to within an hour or so being in the thick of the fight. And then I'd scroll down to the bottom of the statute, and here's my case notes that are dealing with unauthorized use of name or likeness in the Pennsylvania statute. And then there's also two types, Lexis and Westlaw, they do have subject searching as well. So when you log into Lexis from the home screen, click on topics, and you can run a search in topics for whatever, right to publicity. And I can see under the topic, right of publicity, Lexis gives me, and I think I narrowed my jurisdiction down to Pennsylvania. So in Pennsylvania, the Lexis topic on right to publicity gives me several opinions, so I can get at it that way. And similarly on Westlaw, from the Westlaw homepage, under content type, there's a key number link in the middle, and then I can search right to publicity, and then I'll eventually get to a topic, a key number, and there's my Facinda case that way as well. So now we get to the most important part here. How do you know that a case or a statute or an agency regulation is still valid? It hasn't been superseded, it hasn't been overruled, it hasn't been deemed unconstitutional. How do we know this? Any thoughts on that? What are we going to do? Yeah, Carrie.
I was pulling up, well, for cases and then looking at the history of the case because it puts it in that little chart thing and it'll tell you if it was affirmed or overturned, and it gives you the little indicator.
Right. Yep. So that's your key sites. That's your key site treatment in Westlaw. And then it would be Shepard's and Lexis. And then also you would check on that key site in Shepard's for the citing opinions, because maybe the opinion has been whittled down over time. Like Roe v. Wade. Roe v. Wade is still technically good law, but it's been chipped at by so many courts and so many jurisdictions that Roe v. Wade now is different than Roe v. Wade was back in whenever it was in 74 or 6 or whenever it was. So not only the direct upper case to see whether it's been overruled, but also to see how it's been modified in your jurisdiction. So key site and Shepard's, what are you going to get with all of these flags? You're going to get obviously the prior history and then the appellate history. Has it been overruled by the upper court? Other citing decisions. So you're going to probably want to filter to your jurisdiction. And then finally, you'll get secondary source treatments, law review articles, practice aids, other things that have cited your opinion, that discuss your opinion. Secondary sources are good when you find a case because maybe the opinion is convoluted and they use a lot of big words that I can't understand. So I'm going to go to the secondary source. I'm going to read an article that's a little simpler to digest. Or I might just read an encyclopedia entry that simplifies it to me. It's like, oh, that's what they're talking about. So my warning screen here, the results for Keysight and Shepard's on Lexis and Westlaw, your treatment's going to be different, maybe. So that's why I say use both to double check. Because I pulled up Citizens United here. U.S. Supreme Court Citizens United, the Supreme Court case that says that a corporation is a person, has a heartbeat or something. And I went into citing references, I went negative treatment, and I went Third Circuit. Shepard's gives me 71 and Westlaw Keysight gives me 20. That's a pretty big difference. So you can't rely on your flags. Your flags are just created by a dude or dudette like me who's read the case and assigned the flag. So Lexis and Westlaw treatment may vary slightly. And remember, just because something is distinguished, something being distinguished is probably not a big deal. That court just thinks this opinion has a slightly different fact pattern, so they've distinguished it somehow. The rule of law in the case is still good. And then are these flags necessarily accurate? If you're on Westlaw, you might come across occasionally this overruling risk little doodad. So if your research comes across this Heckler opinion and Heckler is good for you, they're also warning you here, hey, it's still good law, but Heckler relies on this Caden case, and Caden is in risk of being overruled. I mean, that's getting into the weeds a bit, but if Caden falls, then maybe Heckler falls as well. So you might come across that in Westlaw, overruling risk. Okay, my nightly video. This is to illustrate the importance of updating.
Your unfounded allegations will change the truth.
Why don't you address the legal issue on motions to reconsider, Counsel?
Yes, and I meant to start with that, Your Honor. I got sidetracked.
That would help.
I'm sorry. There is no legal provision for a motion for reconsideration in criminal law. That is only in civil law. It is recognized in Civil Code of Procedure, Section 1008. And what they require in civil law is that the party seeking reconsideration show newly discovered facts. In this case, we have no newly discovered facts with respect to the motion for reconsideration of Laura McKinney.
But doesn't the case law dealing with that particular code section include criminal cases? If you shepardize that, you come up with some criminal cases.
We did. I believe that none were found, Your Honor. We don't have any in our motion, which leads me to believe that no, there aren't any criminal cases under that section. And
Sure.
You asked me that question because you knew Ms. Lewis wrote the motion, huh?
No.
But no, as far as I know, there are no criminal law cases that involve that section because it's not recognized in criminal law. So, I mean, at least in theory, we didn't have to have all the argument. But
So if my Pepperdine law clerks found some,
did they? Criminal cases?
So Marcia Clark, lead prosecutor for the O.J. Simpson case, doesn't run a Shepard's report on whatever state rule it was, so she didn't think it applied in a criminal situation, but by gosh, it did. And we know how that case turned out. So, for your research pleasure here, go on to Westlaw and see if you can find this answer. Pennsylvania State Court. Are clients a hotel or a motel? And are they liable for the injury of a guest who slipped on a snow-covered parking lot in the morning after it had snowed the night before? So it snowed all night. So the next morning, patron from the hotel goes out, falls on the sidewalk or in the parking lot? Are they liable for not shoveling the premises right away under Pennsylvania law? And if you think you found the answer, raise your hand. Don't overthink your third search terms. Just think of common search terms. Slip, fall, icy, hotel, motel. Lindsay,
I thought we're putting our hands up when we figured out the answer, correct?
yes. What did you find out?
Well, in all the cases that I've seen, it says that basically the property owner was not liable for injuries sustained by guests when they slipped.
All right. Was there a particular case that seemed good?
Oh, I just got out of it. Whoops.
Morin v. Traveler, did you find that one?
Morin v. Traveler, and there was another one in here from 2013.
Yeah, so Morin v. Traveler, that's usually the one that comes up first.
And I guess Rinaldi v. Levine was also on here.
So for Morin v. Traveler, is there a red stop sign or anything on it? Is there a warning in the database saying that it's a weak case or something?
I'm not seeing any warnings.
Okay. Yeah, I did. Yeah, Jenna.
I thought maybe I'm not in the same place that Lindsay is, but I thought what's the yellow flag? I thought that was something, negative treatment.
Negative treatment. Red is like.
Yeah, you were asking for
Stop.
red only? Okay.
Yeah, I mean, again, yellow just means potential negative treatment. It's not necessarily bad. It usually means it's been distinguished somehow. The facts are slightly different or what. But that's where you, as wanting to become lawyers, it's up to you to click on those cases that have the yellow sign and see why there's a yellow, because they're not gonna, just because there's some negative treatment doesn't mean that you can't use a case. All right. So similarly on Lexis, if we can run this search on Lexis, Pennsylvania. Shakshi, you have a question?
I do, or yes. I mean, I did it on Lexis and it has a positive sign, but there's a lot of like it's referencing subsequent other cases. So like, I'm sorry, I'm still confused. Like if it says like Bonilla v. Motel 6 and it's a positive sign, is that something that then we can use? And where do we find the information at the bottom for us to be like, is this still a good case or was it reversed or something like that?
Let's take a look. You're on Westlaw?
I'm on Lexis Plus.
Okay, let me see if I can figure out Lexis here. And we did So I go into Pennsylvania. I might, because I've been doing this long enough, I might just stick to cases because I know this is a common law type situation, not really a statutory deal, but I'll just leave it open. So hotel, motel, slip, fall, icy condition, just some very general terms, right? Secondary material comes up. Cases, I go to cases. Maybe it didn't like my search. Hotel or motel, same paragraph, slip. Let's try that. Same /P, same paragraph. Okay, that's a better search. Hotel or motel, same paragraph as slip. Here's my Morin. What case were you looking at? Was it the Morin case?
No, so there's actually a case called Bonilla v. Motel 6, and they talk about icy conditions. It says plaintiff adduced sufficient evidence to establish proximate cause. Defendant's contention is not due to, and then unforeseeable or sudden nature of the injury. Like it's there, and it says that if it talks about a specific snowfall, like a snow injury where there was a slip and fall. So do you want me to send you the case?
Yeah, what's the citation to it?
You know, Brent, it's I chatted it to you. I don't know if that helps. I don't know what the I'm copying the citation and sending it to you too.
Okay, the Morin v. Travelers, that tends to come up most frequently in this sort of fact pattern.
Okay.
In,
I think any would be helpful just to walk through and see the specific elements because
okay.
Some of it is jumbling it. I don't know where the cases will become more important, less important based on their history. Like I'm not still finding it, some of that stuff.
So in an opinion, you're going to, in Lexis, they give you these core terms here. Then they give a case summary, which is still editorial enhancements. Here's your head note treatment, right? So each cause of action or element of law or premise of law is assigned its own head note. So if it's a longer opinion, you can navigate to only the section of the opinion that you're really concerned about. In this case, slip and falls, hotels, things like that. The Hills and Ridges Doctrine is a long-standing and well-entrenched legal principle that protects an owner or occupier of a land from liability for generally slippery conditions resulting from ice or snow. So if I'm handling a case like this, that's the sort of, now that I found Morin v. Traveler, I get a general understanding that, hey, there's this thing in Pennsylvania called the Hills and Ridges Doctrine that if all of the facts line up are going to protect my client. So head note 3 is talking about the Hills and Ridges Doctrine. You click on the link, it takes you into the opinion where they discuss Hills and Ridges. So if you're going to cite Morin for that area of law, you would cite this stuff rather than the head notes up above. And then they link to the opinions that they use to rely on their holding. So maybe I take a look at Harmada and Wentz Apartments, etc. Let's see, top. It'll tell you it's the Superior Court of Pennsylvania. So it's not the Pennsylvania Supreme Court, it's an appellate level jurisdiction. So for your citing decisions, caution. So 19 positive citations, 1 neutral, cited by 53 other opinions, and six cases cautioned the Morin holding. I would likely rely upon why it was cautioned. So I take a look at those. Distinguished by, distinguished by, distinguished by. So I would want to see why those cases distinguished it. If there was subsequent history, if it had gone up to the Pennsylvania Supreme Court, that would be in here too. So I would click on that, but it hasn't. It just stayed in the Superior Court. If I know that the Hills and Ridges Doctrine stuff of Head Note 3 is really critical to what I'm researching, I'm going to stay in this Head Note 3 and I'm going to shepherdize by this head note. So I'd click on that link there, and Lexis generates me 52 decisions that are specifically talking about the Hills and Ridges Doctrine in a similar fashion to the Morin case. So is it sort of making a bit more sense? If,
Thank you.
if I go out and I do Citizens United, here's my Citizens United case from the Supreme Court in 2010. $1,400 citing decisions, and then other citing sources here. 110 cases, give it some caution. I'm likely going to likely click on my citing decisions. And I'm going to likely want to restrict it down to maybe the Third Circuit Court of Appeals. Actually, just the Third Circuit Court of Appeals. Since I'm in the Third Circuit, I practice in PA. I want to understand Citizens United, and I want to understand how the cases in my circuit are citing to it. So the Third Circuit opinions cannot overrule Citizens United, but they can apply it in their own specific way. So I would focus in on how my jurisdiction is dealing with Citizens United. If I'm practicing in Pennsylvania, it'd be Third Circuit. If I was in California, I'd be more concerned about the Ninth Circuit, etc. Does that kind of make sense? Click on your Shepard citing decisions, narrow your citing decisions by jurisdiction and treatment. So that's kind of sort of the steps that you do when you're doing case stuff. So this Lexis scenario, I'll just run us through it here. So In Pennsylvania, can someone trim the tree branches that are overhanging from their neighbor's tree without first asking permission? So the elm tree, it's growing over and you wanna lop off the limbs. So back to, I log into Lexis, Pennsylvania. Neighbor tree. And I let Lexis help me out here. I start just with some very broad search terms, neighbor tree, and they give this neighbor tree dispute. So I might click on that to see where it leads me. Run my search. This is part of the artificial intelligence stuff of Lexis and Westlaw. They like to try to fill in stuff for you. Secondary sources is my first look-see. So I might take an overview of these things. I'm going to go right into cases. And you'll see a variety of cases that are pulled with this search term. A lot of these are boundary dispute things, so we're not necessarily too concerned about it. Maintenance by the city. So here we go. Action for damage resulting from the removal of vegetation from property owner's land. Were they entitled to exercise self-help? Well, that sounds promising. So I'll click on the Jones v. Wagner case. Self-help, encroachment, plaintiffs. So they give you these core terms. So if you arrive at an opinion that's sort of on point, they're helping you out with core terms. So these might be some terms that you could throw in subsequent searches. Preliminary objection was not granted because there was a case. Screen my head notes. Head note 2, self-help. Removal of branches is an appropriate remedy when encroaching branches simply intrude into the adjoining landowner's airspace. So under self-help doctrine in Pennsylvania, I can go outside here and I can chop off Dan's limbs that hang over my fence. Shepherds, I'm going to want to shepherdize my document to make sure it's still good law. No citing decision, so well, I guess that's good and bad. So basically it's just, this is a common pleas court in Montgomery County. Hasn't been overruled, but it's good for kicking off your research at least. No head note treatment either. So at least with this, I can then take, I now know self-help, I know neighbor, I know dispute, and then I can rephrase my search and see if I can find any other cases beyond Jones v. Wagner. So that's kind of how I approach things. If I can't find a secondary source, I go into cases, find one that's sort of on point, use my head notes to find other cases if they're there, and then go from there. Does that all sort of make sense? So yes, you can trim the limbs. On the Morin v. Traveler, slightly different treatment for negative treatment. In Westlaw, they say there's one negative case. and Lexus Advance Morin gets 5 negative cases. But again, remember, that's just the lawyer editor saying it's a negative case. So again, it's up to you to interpret the flags. So pro tip number 1, remember to use your head notes to find other cases that are similar to it. So more cases like head note 4, or you can also move over here in Westlaw to the topic and key number to find other cases as well. If you clicked on this 379K 389 link, that would gin up a bunch of other cases dealing with the head note 4 language. And then pro tip 2, remember on your key site, use your filters. Negative treatment, your jurisdiction, you're only concerned about Third Circuit, etc. All right. And then to close out the night, the legal research project. Actually, for you guys, it's already posted. It's 6 questions. Basically, it's asking you these things. Very simple fact pattern. Can you find a couple of secondary sources that will help you understand it? Do these secondary sources lead you to a statute? Does the statute notes lead you to a case, to 2 cases? And then those cases, by shepherdizing, will give you more cases. Yes, Jenna.
I'm sorry, I'm still just struggling a little bit with the different syllabus and the reading and video, all the different documents. So this is, assignment is due, where, do you know where it's listed and when it's due?
I'm not sure exactly
seeing
where
this
it's. This is the legal research project.
Is this the big one? This is not the, this is like a small,
no,
one. Yeah,
it's-
this
no,
is like
it's
a
just a
small
teeny-
one, yeah.
It's a teeny tiny small one. Do not this Saturday, but next Saturday, the 6th by midnight,
Okay,
59.
thank you.
It's 6 questions. It should take you less than 30 minutes. So find a couple secondary sources, find the statute, find a couple of cases, and then give a conclusion of whether you think, yes, Shakshi.
I have 2 questions. First is, does it matter if we use Westlaw or Lexis?
No,
And my second question is, are these PowerPoints available somewhere, just if we want to refresh our learning?
sure, I can forward them to Rob. Yeah, Gulp,
Thank you.
you're welcome.
And this goes to, we put it on Twin? Is there?
Yes, right. You'll just upload it back to the Twin. And then after I get them all, I'll go through them. I'll fire out a sample answer to you guys. And then I'll also make a video of kind of what I did to arrive at my conclusion. So you'll get the canned answer and a video on it. Were there some more questions? Yeah, there's the one on the 4th is the rules assignment. And you'll be doing the rules assignment in class next Thursday. I think I'll be logging in with you and I'll be available for questions on that one. You should be able to get the rules assignment done in class that night, next Thursday. All right. All right, I guess that's it. So if there's no more questions, I'll see you, I think, next Thursday.
Thank you.
Thank you.
Thanks,
Hi,
guys.
thank you.
Thank
Right,
you.
thank you.